So I hope you enjoyed that song. I always think about that song whenever I start talking about writing letters. It just, I don't know why, it just always comes to my brain, so I thought I would share it. I also wanted to share this little Groucho Marx clip, and if I can get it to play in this video, I will. If not, I will put a link to it in the chapter. So let's see what happens. Nope, it didn't work. So you can pause and go and look at the video. This is a quote that I like. It's from Brian Garner. He's the editor, or the current editor, for Black's Law Dictionary. He is a legal writing expert. He says, "You'll be judged by the letters you write and the emails. That should come as no surprise. People will gauge your intellect, your care, your confidence, your poise, your considerateness by your letters. Neglect the skill of letter writing at your peril." I think that's important to keep in mind because so much of what we do in the legal profession is carried out through letters. We send a lot of letters. And of course now we do use email to communicate, to send those letters, but they're still in letter format, and we tend to still send paper letters as well, hard copies. So letter writing is a skill that you really need to master. So here are the mistakes that students tend to make with regard to letters. Number one is using a poor format, meaning not structuring your letter in a letter format. And we're going to talk about different formats later in this lecture, but it's amazing to me the number of people who do not know how to write a proper letter and use the proper format. I can remember in elementary school that learning how to write letters was a very big part of our curriculum. I remember it being done every year. We would have a unit on letter writing. So I don't think that's something that's actually being taught in grammar school curriculum anymore, and I think that's a real shame. The next is failing to adopt a natural tone, not being able to communicate in a casual, and maybe casual is not the right word, but not being able to easily communicate in this format. Grammatical, spelling, and punctuation errors. People tend to think, oh, with letters, I've got this, I don't have a problem, and then they don't proofread, and your letter speaks to you, and so you need to make sure that it is correct. And then the last one is trying to just send a form letter, just taking a letter from somewhere else and just swapping out a few words here and there. You want it to be personal, okay? That is the purpose of a letter. So written communication, the primary form of communication within the law office and outside the world, in the outside world, is written communication. Writing is crucial to modern organizations, and which is very important in the legal profession, it serves as a major source of documentation. It's where you are tracking the things that you are doing. And employers are going to look for good communication skills. So what is correspondence? I've had people, students in my class, when I say the word correspondence, well, what does that mean? Okay, it just simply means communicating through letters. So what is a letter? A written or printed communication directed to a person or organization. Letters can be created and sent as email or some other form of electronic transmission, facsimiles if you still have a fax. They can be hand delivered, they can be sent through regular mail, and we still use snail mail to send letters. Why does legal writing matter? Well, or why does letter writing matter? Letters should be truthful and correct because they serve as the permanent record. As I've already said, they are documentation of what you've done, of conversations you've had. They become part of the client's file and part of the record. And you need to be careful with the things that you say in letters because letters can come back to haunt you. Letters also reflect your character and your skills as a communicator. So you need to be sure that everything that you are communicating is correct, is truthful, and you are okay with it becoming part of the permanent record. Here we have the 5 main stages of writing business letters. Writing any legal writing: pre-writing, drafting, revising, formatting, and proofreading. Pre-writing is that planning stage, and you need to take the time to do that. Figure out what the purpose of your letter is, who are you actually writing to, because that's going to determine your tone, your language. Collect whatever information you need, whether it be research or just general information that you need to draft your message. Use an outline, just plotting out the main points of your letter. I know we all hate using outlines, but it really will help you. The drafting stage, the second stage, organize that information that you've collected, your research, and begin formulating the words, tailoring the language to the audience that you are writing to. Then you want to revise, okay? Figure out how can you make this more concise, more directed to the reader. Make sure you're formatting correctly, how you're packaging your message. Make sure you're following a format that is consistent throughout the letter. That's probably more important than what format you choose, just being consistent. And then finally, proofreading. That's probably the biggest piece. Make sure that you proofread it. Read it out loud. Put it aside, come back and read it later so that you can catch your errors. 7 C's of business letter writing. Be clear, be concise, correct, courteous, conversational, convincing, and complete. Be careful with the use of pronouns in your letters. Number 1, don't ever refer to yourself in the third person. Here is your one opportunity that you can actually use I and we. It's perfectly natural to speak that way when you are drafting a letter. Keep your focus. Be focused in your letter writing. Make sure that you are addressing the point that you need to make, but avoid choppy sentences. There's that balance between being focused and concise and being short. You don't want to cross that line. Don't be so concise that your tone is blunt. Depending on the type of reader, tailor the terminology to that reader. If you are writing to a client, you want to use as simple terminology as possible. Avoid legalese. Whereas when you are writing to opposing counsel or someone in business, you might can be more use more terminology or legal terminology. Avoid vagueness. Be specific in what you are instructing the reader to do or asking the reader to do. We've talked previously about making sure you use active voice versus passive voice. For example, this sentence is passive. It was discovered that the salary totals were incorrect. Well, in a sentence like that, we don't know who discovered it. Was it someone who got an incorrect paycheck, someone in payroll, someone in accounting, an intern, the IRS? That leaves too much to be interpreted. Use the active voice. The accounting department discovered that the salary totals were incorrect. That is much more focused and to the point than using the previous sentence. So, how many types of letters? Well, it really depends on the textbook that you are looking at. I tend to group them in 3 types. One is a general informative correspondence. Then you have demand letters, and then opinion letters. Now, what does it matter? Well, it matters what your purpose, your letter purpose is, and it also affects who can sign the letter. Now, you can draft all of these letters, but when it comes to demand and opinion letters, that is the practice of law, and you will not be able to sign those letters. It's going to have to be signed by the attorney. So, a formative letter, an information letter. You're giving general legal information or background about a legal issue. You're writing to tell the client that or confirm that they have an appointment with the attorney. Hold on. Sorry, the voice was starting to give. It's going to have an introduction or an opening. You're going to give either an answer to a question that the person has asked or an explanation about something, and then a closing. Usually going to be a very short letter. Then you have opinion letters. Those are letters that give information about the law, probably some analysis of the law, and a legal opinion or legal advice is given. Usually that's when we've gone and done some research or we've had a client ask a particular question and we, the attorney, are providing them advice in this letter. You can draft that letter, but it has to be signed by the attorney. So you're going to have an introduction, an opening. You're going to present the facts related to this particular client or this particular case or just this particular situation. Then you're going to give the answer, a conclusion, an explanation about why you are providing this particular advice, and then the closing or conclusion. And we'll talk some more about the analysis related to this type of letter towards the end of the lecture. The third type is a demand letter. Those are letters designed to persuade someone to either do something or stop doing something that's detrimental to our client. Okay, so you're asking someone to either do something or stop doing something. You have to be very aware of the language that you're using. You don't want to be confrontational, but you want to be firm. You want to, any consequences that you list, you want to make sure that those are things that you or your attorney is actually going to follow through with Don't make empty threats. Demand letters probably require the most finesse so that you don't come off as a bully. You're going to have that, once again, an introduction, some facts surrounding this particular issue, the explanation of what you're asking them, this person or this organization, to do, and then your closing. Demand letters, as I said, are probably the most difficult. You need to be clear and straightforward, stating what you're wanting them to do and why you're wanting them to do it. And if they don't do it, what those consequences are going to be. And as I said, you need to make sure those are consequences that you and your attorney can live with, and your client. Don't argue in the letter. Provide any documentation that you have to bolster or support what you're saying in this letter, and provide documentation of any damages that our client is facing. You know, if we're dealing, let's say, with a car accident, providing hospital bills, invoices, things to support the claims that we are making in the letter. Okay. So here's some examples. General correspondence or informational letters. Client needs to know that we have a deposition scheduled next month. You can write that letter, you can sign that letter. A demand. The debtor needs to understand that failure to repay the client will result in litigation. You can draft it, but you cannot sign that letter. An opinion letter. Client needs to be provided advice regarding cutting down trees, excuse me, trees on a neighbor's property. Once again, you can draft it, but you cannot sign that letter. So the elements of the letter, we're going to get into format now, what it needs to look like. Most law firms are going to have pre-printed letterhead. If they don't have pre-printed letterhead, they're going to have a template, an electronic template that would have what would normally be in their letterhead already set out in that template, and then you just fill in the letter parts. But typically, the nicer the firm, the nicer the letterhead is going to be. And when I say nicer, I mean the more prestigious, the more successful they are. You're going to have the date, and the date is very important because you're stating, especially in an opinion letter, this is what the law is as of this date. Or if you are making a demand, you are setting up your timeline based on the date of that letter. So it's very important to make sure you have the correct date. You may also have the method of delivery. Okay, some attorneys I see put that method of delivery on every single letter. I don't know that's necessary. I think it's only if you are, sending something electronically, but then you're also sending it by mail or by overnight, then you would want to indicate that. Then the inside address, the recipient's address, who is it going to? You want to make sure you have the correct address and you are addressing the letter to the correct person. You want to have a reference section that gives the reader a short clue of what this letter is about. Usually it's going to have, what the client's name might be, or the file number, or if you're dealing with an insurance company, what their policy number is. Something so that the reader can identify what this letter is about. You're going to have a salutation. That's your greeting. You're going to have the body, which could be multiple paragraphs, an introduction, the main body, and then some instructions. Then you'll have a closing, and we'll talk some more about that in a minute. A place for the signature, and then reference initials of the person who drafted the letter but is not necessarily signing it, or the person who typed it but not signing it. If copies are going to someone other than the addressed recipient, if there are any enclosures. So those are your basic pieces of a letter, parts of a letter. So here's a few comments about general business letter writing. Business letters are required in many different situations. You're going to be using them a lot, whether you're applying for a job, requesting information, giving information, you're going to be using letters. Writings for business should be crisp and succinct and should be to the point, specific, and accurate. Even though business letters or business writing is probably less formal than it used to be, your writing must still adhere to conventional American English, spelling, grammar, punctuation. So these are the three main layouts for letters. You have semi-block, modified block, and block style. Block style, you might also hear it called left justified. I am a block style letter writer. A lot of what you will be writing will depend on how your attorney writes. They will expect the letter to be drafted a certain way. If you're writing a letter to me, or writing a letter for me as my paralegal, I want to see it in block style. Okay, so let's talk about each of these styles. So the first is that left justified block style. Everything lined up on the left side. The only thing that might not be lined up is that letterhead. If you're using pre-printed letterhead, it's probably going to be centered at the top. However, I've seen more and more legal professionals using different formats for their letterhead, sometimes with it on the bottom or down the side. The side is a very popular format these days. But other than the pre-printed letterhead, the remainder of the letter is left justified. Everything is lined up on the left-hand side. Okay? Within, and this will come later, but within a letter, you want to single space within the paragraph and then double space between paragraphs. So single space within the paragraph, double space between paragraphs. This next is the modified block style. Here, everything is pretty much left justified except for the signature section. It is lined up almost starting at the center of the document and going to the right. And then finally, we have semi-block style. And depending on I would venture to say, depending on the age of the attorney that you're working for or their background where they first learned, you might see this semi-block style in an older attorney where they're going to indent each paragraph, and an indentation is 5 spaces. Okay, sometimes students get confused and they just will do it 1 or 2, but a true indentation is 5 spaces. And in a semi-block, you indent in every paragraph. You're still single space within the paragraph and double space between paragraphs, but you are indenting each paragraph. Greetings. A business letter starts with a simple and professional greeting. Dear Mr., Dear Mrs., Dear Dr. Smithsonian, if they have a particular title that they hold, Dear President Holston, you want to include their position as part of your greeting. And the difference between a personal letter and a business letter is that a personal letter would have a comma after the greeting, and a business letter will have a colon. The body of the letter, that's where you're going to make that decision. Are we going to be full block, modified, semi, single space within the paragraph, double space between paragraphs? You're closing the end of your letter marks probably one of the biggest differences between business and personal letters. Usually you are going to state something like sincerely, followed by 3 to 4 blank lines, then the signature and the writer's typed name. Those 3 blank signatures are for those 3 to 4 blank lines are for the signer's signature. Now, once again, back to if you're working with an older attorney, they may use a closing such as very truly yours. That is the most formal closing in a business letter. It doesn't sound like it, but very truly yours is the most formal, and many attorneys, especially older attorneys, are still going to use that type of closing. So here we've got a copy of a letter. It is full block. I would dare say it's probably a little too long. It's something I would also probably break it down into smaller paragraphs, more digestible by the reader. Here is a video about formatting within Word for letters, and I will put a link to this in the chapter folder. And last, we want to talk a little bit about the analysis structure for letters, especially in something like an opinion letter. You want to, once again, follow that IRAC process, identifying what the client's issue is, and we will have done research to determine what's the rule of law that applies, and then how is that rule of law going to actually apply to our client's problem, and what is the conclusion. So that's the process you'd follow for the body of the letter in an opinion letter. If you've got to discuss a particular statute that affects our client's case, you want to quote that statute. You want to break it down into its elements and address each of those elements. So here we've got a statute. Any private, verbal, or written communication between a husband and wife is privileged, and a party possessing the privilege, the accused, may not be required to testify and may prevent the spouse from testifying. So what are the elements? Well, we've got to have it, it's got to be private. It's got to be a verbal or written communication. We have to have a husband. We have to have a wife. It must be privileged, and the party possessing the privilege can not be required to testify, and they may prevent the spouse from testifying. So breaking it down into each of those elements that you're going to then explain to the client. Okay, so That concludes our chapter on letter writing. I hope it helps. You've got an assignment for letter writing, and I look forward to reading your letters.